Today we're going to talk about sexual harassment in the workplace, and there are two fundamental fears under which a lawsuit can be brought. One is referred to as a hostile work environment, the other as quid pro quo. Hostile work environment is often defined as uh, intangible employment action, um, and involves some sort of a um, unwelcome conduct of sexual nature that creates offensive work environment. Quid pro quo, on the other hand, is a little bit of a higher standard and is referred to as a tangible employment action and involves a desire to exchange sexual favors for something tangible, such as promotion, raise, whatever. Uh, Additionally, under quid pro quo, we have to remember some sort of a power relations has to exist between a plaintiff and the defendant, the boss employee relations of sort. Uh, there has to be some kind of a supervisor role on the part of an offending party. Uh, Now, one thing that both rules have in common is that intentions and intent is irrelevant. The impact is the only thing that matters. That's why excuses such as "I didn't mean it" are truly irrelevant in those cases. Since there was a lot of confusion originally as to what exactly the tangible employment action and hostile work environment mean, the Supreme Court in 1998 spoke about it. And here's the quote from the Supreme Court. Tangible employment action involves situations where a supervisor has taken significant adverse tangible employment action, such as discharge, demotion, undesirable reassignment against a subordinate employee for the employee's refusal to submit to the supervisor's demand for sexual favors. And now, hostile work environment. With this type of harassment, an employee's economic benefits have not been affected by a supervisor's conduct, but the supervisor's sexually harassing conduct has nevertheless caused anxiety and poisoned the work environment. Such conduct may include unwelcome sexual flirtation, propositions, use of degrading words, or the display of sexually explicit or suggestive pictures. Now, if the claim involves unfulfilled threats, so for instance, a boss threatened to fire a person for not granting a sexual favor. In this, in those cases should be categorized as hostile work environment, and should such claims should show a severe and pervasive impact. The keywords here are severe and pervasive. In cases when managers have been found guilty of employee harassment, employers are automatically liable of tangible employment action, quid pro quo, because managers and any sort of supervisors serve as agents, empowered agents of an organization, and there is no affirmative defense based on even existence of a anti-harassment policy that simply is not admissible and will not help the organization. On the other hand, if no tangible employment action was taken, affirmative affirmative defense does exist, and employer has to prove two things. Number one, that they did take corrective actions, immediate corrective actions by, for example, publishing anti-harassment policy, and number two, by proving that employee was not able to take advantage of those corrective actions by, for example, not reporting the case to the management. We also have to remember that not everything goes, and the burden of proof is really on the plaintiff, or potentially offended employee, who has to prove, and here's the quote, that the harassment was so severe and pervasive that it affected a term, condition, or privilege of employment. And that is judged by the reasonable person standard. So we might reasonably imagine that a woman who is so sick of her coworkers' sexist jokes to avoid those kind of circumstances has to use back door to enter the building. That certainly would qualify as severe and pervasive. Now, whereas organizations' responsibility for sexual harassment, for managers' sexual harassment towards the employees is a little bit more of an obvious thing, easier to understand than the co-workers' harassment of each other, employee versus employees, is a little bit of a different situation. And in those cases where there is no power relations in between employees, in those cases, organization is only liable when they knew about it, or should have reasonably known about it, and did not really do anything about it. Now, employer's liability for non-employee sexual harassment has usually to do with employers requiring employees to wear sexually explicit uniforms in situations where employers should have reasonably known that such a requirement will lead to an offensive behavior on the part of patrons. And here one case I can bring to your attention in EOC versus Sage Realty Corporation. A female lobby attendant was required to wear a uniform that resulted in her being subjected to sexual propositions and lewd comments by passerbys. The court found that the employer, Sage, had violated Title VII of the Act. The court accepted the principle that an employer may impose reasonable dress requirements, but held that the employer did not have the unfettered discretion to force employees to wear sexually provocative uniforms.